Good afternoon, everyone. It's a pleasure to be here. As Michaela mentioned, I've taken on the role of director of our Center for, and the acronym stands for Research, Evaluation, and Action Towards Equal Justice. And so we're working on access to justice-related research, evaluation, and action-oriented projects to improve access to justice in Canada and specifically in Saskatchewan. So it's my pleasure to be here to co-host the panel and to welcome the Honourable Justice Williams to the College of Law. Before we begin, I would like to just say a couple of words. As we gather here today, we acknowledge that we're on Treaty 6 territory and the traditional homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another.
Thanks, Bree. So let me take a moment to introduce today's guest to you, the Honourable James Williams, who's known to most as Jim. Over his 3 decades as a Justice of the Supreme Court of Nova Scotia's Family Division, and I have to emphasize that, 3 decades in the Family Division. I just learned that he was appointed to the Family Division at the age of 36. And during that 30 years, I just want to make a quick note here of what he's accomplished. So for a long time, he's been considered a judicial leader across Canada, and not only across Canada, but in the world as well in this field. His background is unique. He has a degree in psychology from the U of A and a master's degree from the Maritime School of Social Work. And I suppose you might say that has positioned him to enter into family conflict as a judge with some particular insight into what people need and in how to move things forward inside family conflict. In this area, he's become known as a strong advocate for children's rights with a deep understanding of children's needs. His involvement in the education of judges and lawyers across Canada and across the world, and his commitment to continue to push forward with innovation in the development of process across Canadian courts has positioned him as someone who really has had quite an influence in the development of family systems, family justice in Canada, and we hope positioned our system to begin to serve the needs of Canadian families better. And those are some of the themes that he's going to talk about today. So join me in welcoming Justice Jim Williams.
All right, can you hear me okay? Great. First of all, thank you for the invitation to be with you this afternoon. I grew up in Edmonton, so my memories of Saskatchewan are kind of limited to the sea of green that would be at Eskimo games when the Rough Riders there. So in honor of that, I made my lecture notes in green. Also, 30 years sounds like a long time. It brings to mind when I was a fairly junior lawyer and was acting for somebody who, given my years at the bar, I probably shouldn't have been acting for at the time. I was acting against a very senior lawyer on the other side. And that senior lawyer continually was saying to me, I've got 25 years of experience and you've got 3 and blah, 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 and was doing his best to intimidate. And I remember talking to one of our senior partners who was an absolute gentleman named Bruce Nickerson. And Bruce said to me, well, you tell so-and-so that he doesn't have 25 years of experience. He's got 1 year of experience 25 times. And Bruce's point was experience means nothing if you don't learn from it. All right, access to justice, what's a family judge to do? I'm going to speak to you about some of my thoughts that have coalesced over the last few years when I've had more of a chance to sit back and think about some of my experience. I enjoy doing this kind of thing because I always feel I learn at least as much, if not more than my audience. My family would say I always learn more than my audience, but my experience is in the area of family law, and has been limited to that. I feel both somewhat constrained and narrowed by that, but also very, very lucky because it's an area that's been dynamic and in which there's wonderful collegiality. In terms of access to justice and family law, our focus really begins, I think, with the Cromwell report in 2013, which said that family law was too complex, too slow, and too expensive. So cost, complexity, divisiveness, I would add to that list, the fact that family law is embedded in an adversarial model and is dealing with family problems, delay, legal uncertainty, and problems that we've had systemically because of the large increase in self-represented litigants and clients to the system are all part of the mix in terms of dealing with access to justice issues in family law. The Cromwell report called for culture change and also speaks of implementation delay. It really didn't say very explicitly what's meant by culture change, and I hope to address that a little bit. How do we get to where we are in family law? Well, family law issues are easy to identify. Child custody and parenting, child support, spousal support, division of property, child protection issues, child welfare issues. They're issues that all of us have, all of our families have, and in today's world, there would be scarcely any family that hasn't had a toe, a foot, or an arm and a leg in the family law justice system. I think that these issues are different than the issues that are dealt with in a lot of other parts of our legal system. For the most part, when we're dealing with family law issues, we're, as judges and as lawyers and as participants in that system, restructuring families. There's something that's changed in the family. People have separated or people have gotten together. People have repartnered. People need help determining what their obligations are within the family in a financial sense. People need help determining what the parenting plan is going to be. They involve relationships that have a history and a future. And this is really, really important. Most areas of law, be it criminal law or civil law, involves litigation, involves a dispute, a trial, a conflict between people who are not likely to have contact with each other again. So the trial process, the adjudication process, or the negotiated settlement is an event that is, in family law, we're dealing with people who have a history, and that history is usually emotional and involves some disappointment, some anger, but there's also a future, and the future part of it is really important where there's kids, because I might be dealing with a child custody situation, a parenting situation with a 5-year-old or an 8-year-old or even a 12-year-old. But what we do is going to have an impact on that family for literally the rest of their lives. And this is an area that I've come to change my views on, and I talk to people in the courtroom about this. As my own family got older and my children became adults, I came to realize that, one of the most enriching pieces or parts of parenting is the relationship you have with your adult children. And it's something I really value and I feel very lucky about, but it's changed my view of what I do in terms of the long-term impact, and it's changed how I approach things. In family law, much of the time we're talking about what will happen as opposed to what did happen. So the nature of evidence, the nature of the dispute itself, how we resolve it, what's important to know or not know, is quite different than in criminal law or civil litigation. Claire Huntington, who's a American academic, wrote a book called Failure to Flourish: How Family Law Undermines Family Relationships. Not the nicest title for those of us involved in family law, but a very insightful book. And one of the things she says is that the substance, process, and practice of family law is built on the same adversarial system that we use for parties with no emotional connection and who need not interact in the future. And that's something that we need to think about, and we think about more. So what do I mean by adversarial system? Well, the adversary system is kind of the basis of our legal system. It assumes really three things. One, an impartial passive decision maker. So that would be the judge. So when I came to judging as a baby judge, my role was pretty simple. Sit, listen, decide. Even the way we talk about judges is infused with this model. We talk about judges sitting. That's not the most active kind of descriptor of what we do. A second characteristic of the adversary system is formal rules of evidence and procedure. And this is really important. This is the language of our culture. And so one of the things, if you have 2 or 3 takeaways from this, and that may be that may be optimistic, but one of the takeaways I think should be, think of, when we talk about culture change and access to justice, think of every culture, every group of people who have a cultural identity. Language is really important to them. And in the legal business, in our legal systems, our language is basically in our rules of evidence and rules of civil procedure. And again, if we say, okay, what we want to address with access to justice is we want to make it more, our system more understandable. We want to make our system not subject to delay. We want to make our system less costly. We have to pay attention to this. The third characteristic of the adversary system is that the parties are responsible for what issues are heard, the gathering of evidence, the presenting of evidence, and the contesting of evidence. So, how does that work in a world where there's a lot of self-represented people? In a word, poorly. Because if there's a lot of self-represented people who don't know the culture, who don't know the language of the law, then having them responsible for the whole process is going to be problematic. Now, the whole adversary system is built on the assumption that there will be translators. There will be advocates. There will be lawyers who help lay people negotiate through all this legal language and that. Now, the adversary system has lots of advantages. There will always be trials. There will always be problems. There will always be circumstances in family law that require a trial. An advantage of the adversary system is the rules are predictable. They're even centuries old, the roles. within it so that it's easy to know what you're supposed to do or not supposed to do. The trial's an event. It's done and it's over. And one advantage is that it's controlled by the parties. It's also a disadvantage if the parties have a difficulty fitting within the expectations of the family justice system. It's the best way we have to resolve disputes at this point in time, but it need not be the only way. And if the adversary system is the emperor of the family justice system, let's not forget that sometimes the emperor has no clothes. And in family justice, it's critical, I think, and I'll speak to this a bit, that we develop, that we not be static, that if we're going to address the problems that Cromwell and other people have identified, that we zero in on what causes those problems. So that we have to evolve, we have to develop options. Sometimes we say we're reluctant to change the adversary system because we say it's fair. Well, there's two kinds of fairness. There's fairness about outcome and there's fairness about process. And we know that in whatever the issues before a court, whether it be family justice or other, there are different views about fairness. We also say that the justice system, or the adversarial system, is based on principled rules of evidence and procedure. Well, Chief Justice Dixon, then of the Supreme Court of Canada, said about evidence law, we start with the fact that the law of evidence is burdened with a large number of cumbersome rules, with exclusions and exceptions to the exclusions and exceptions to the exceptions, and on and on. We have whole courses on evidence in civil procedure in law school. It's a dense language, even for law students and lawyers. It's complex. We shouldn't be surprised that litigants who are self-represented have trouble understanding it. I think, too, we have to remember that there's limits on what information provision can do to address access to justice. If you could learn civil procedure just by reading some information pamphlets and going on the internet and working your way through a couple of exercises, law school would be a lot easier. But you can't. And we shouldn't be surprised when it's not the full answer for litigants. I sometimes think, I don't know anybody who learned a language from the Rosetta Stone. So we shouldn't be surprised. Those programs are necessary, they're helpful, they assist, but they're not the answer. They're part of an answer. We also talk about the adversary system being fact-finding. And in family law, if we're dealing with the parenting in the future, I'm not saying there's never fact-finding. If there's allegations of abuse or there's something specific, then that's obviously there's a fact-finding exercise or a determination of what an income is or whatever. But to a large degree, decisions are based on proof, not truth. So you will not read a judgment written by a judge that starts with, the truth is. You've seen lots of decisions that say based on the evidence. So there's a difference between proof and truth. And where that's important is the adversary system is based on the litigant bringing the evidence. So what I get to make conclusions from in a traditional model is what the litigant brings to me. And if that litigant is challenged or limited, then the information I have to make a decision on is going to be challenged and limited. The adversary system polarizes. That's what it is. It's a contest. One of the things that's ironic when we talk about fairness and truth, and that is, we've all watched the TV programs and where cross-examination is designed to mix up a witness. It's designed to confuse a witness. A successful cross-examination may get a witness contradicting themselves all over the place. I'm not sure that that's a pursuit of truth, as it is a pursuit of proof. All right. Family law has changed a lot. I'm really proud. One of the things when I look back, I think sometimes we beat ourselves up in the legal system a little bit. We deserve to get beat up lots of times. I would never say never. But in the family law area, there's been lots of changes over the course of my career. Now, if somebody stays long enough, like 30 years, then there should be lots of changes, arguably. But if I look back, like one of the criticisms of family law for a lengthy period of time was that child support and spousal support were really unpredictable. Well, Canada is an absolute leader in developing child support guidelines and spousal support guidelines, which provide a lot of predictability and a lot of transparency to what's done in the support areas. Not that long ago, there was no such thing as parenting information sessions or parenting education sessions or litigation, family litigation preparedness education. That's all developed. The bar has really tried to attack the divisiveness in family law with the development of collaborative law and more emphasis on negotiation. Accessibility has been tried to be addressed by the bar with unbundled legal services. So there's lots of places we can point to where changes happened, and the whole paralegal issue is an issue that's certainly facing the entire family justice system and legal system generally. So there's lots of areas of change or pressures to change. But I think one of the important things for judges is to support change in all of those areas. But I want to talk a little bit just about judges. So in my note I say I come to judges, to myself. So the talk of an implementation gap in terms of access to justice issues is really important. It's a phrase that I think translated means it's really frustrating. We don't seem to be able to change anything. We still have delay, we still have cost, we still have self-represented litigants who don't understand the system or what's reasonable, and it's compounded by an internet that makes everybody an instant expert and people dumping large truckloads of documents and things on courts and that. The Norgrove report was a report in the United Kingdom that was done in 2011, and it's kind of the UK's Cromwell report, but it's focused on family law and family justice. And Norgrove, who I've had the pleasure of meeting, not a lawyer, no family law background. He was chair of the board of, I've gone blank, big UK department store. Nobody's got it. Anyway, he was actually Margaret Thatcher's executive assistant at one point. I think the report is really insightful. One of the things he says is about family justice is that strong leadership and management are needed for any organization or system to fulfill its individual or collective objectives. For family justice to begin to operate as a system, it needs to have an owner. Somebody needs to own it. Somebody needs to be responsible for it. And he goes on to say a change in judicial culture and behavior is needed. I absolutely agree with that. And one of the things about being a judge and judges is, I don't know if I would go so far as to say that we should own the family justice system, but I would say that there's not a lot that can change without us being part of that change. And so some of my views about judging, I believe strongly that there's no right way to judge. I think there's lots of wrong ways, but I don't think there's any right way. I think just like when you are lawyers, there will be different ways of approaching any given client, and that you may bring strengths to one situation and a different approach that another colleague would do differently, but maybe just as effectively and maybe more effectively. As a judge, we have a lot of discretion in what we do. I think there's a really, really big professional responsibility on judges to do their best to exercise informed choices. So I think it's important that judges commit to lifelong learning, or at least as long as they're judges. And I think that's one of the great privileges and the wonderful thing about being a judge, or for that matter, a lawyer, is the expectation that you keep learning, that you do something better tomorrow than you did today. That if you make a mistake, if you fall short, that you do your best to do better. I think that process is really, really important to family justice litigants and to litigants generally. Process contributes to the perception of fairness or the perception of lack of fairness. Okay, there are a couple of impediments to judges exercising leadership in the access to justice area, or in any area for that matter. One is the traditional view that it's no part of the function of a judge to provide leadership to fellow judges, that we're all equal. Well, I think that ship has sailed. I've learned lots from fellow judges, and I like to think that, in certain circumstances, I've got something to offer them. I think we can all lead in our own ways, and I think we can all learn in our own ways. Precedent inhibits change somewhat. I think our charter is significant in terms of its embracing of law evolving and changing with different times and circumstances. And I think we have to look at some of our processes in that way too. I think judges have done an okay job to some degree in terms of helping with the access to justice issue. We've, I think, been generally supportive of the development of information programs for litigants. The Supreme Court of Canada has created what it calls a duty to assist self-represented litigants. In other words, as a judge, if a self-represented litigant is before me, there's a duty to assist. What the Supreme Court of Canada hasn't been able to enunciate really is what the difference is between assisting or providing information and providing legal advice. And that's a dilemma that every court struggles with. Every court service that's attached to a court struggles with a mandate that seems to be you can provide information but not advice. And it's a bit of dancing on the head of a pin, in my view. Judges' roles are evolving. So if we go back and we say, well, access to justice in the family law area is rooted, our issues in the family law area are rooted in our adversary system. And we say, okay, we've got difficult language and complex rules of evidence and procedure. Should we be surprised that self-represented litigants have difficulty with subjects that lawyers and law students have difficulty with? The polarization is clearly an issue in families that are going to have to deal with each other in the future. So one of the issues in family law dispute resolution is, does the dispute resolution process capacity build? And what's meant by that, does it equip the people involved in that dispute to handle the dispute that's coming next? The fight over, and it can be as basic as there's only 2 tickets for the Christmas concert and both parents have repartnered. or there's an aging grandparent, or whatever. Delay is a major issue in family courts and courts dealing with family law. If we say that the parties decide what they bring, and we say there's no limits on that, and I bring in days of evidence to deal with something that's just not that, does not require that, but I'm the one as the litigant who decides that, then we're going to have backups. And we do. Cost. The more complex the rules and procedure, the longer trials are, the more lawyers are paid by the hour, the more cost to individuals. So one of the things that I like to do is I like to think of family disputes as requiring dispute resolution, not so much adjudication. I think adjudication has to be one of the menu items that courts specializing in family law issues offers. But I think one of the areas that to me has some potential in terms of addressing access to justice is having an expectation that courts develop new processes. Now we've seen that. When I started judging, there was no such thing as a settlement conference. We went through a period of time when a lot of judges said, well, you can do a settlement conference, but I'm not because it's not part of my role. And now almost every court in the country has settlement conferences as a regular part of their rota or what they do. And in that situation, it's the simplest way to describe the judge's role is facilitative. If you like a mediator, but clearly imbued with the authority that a judge has, and publicly, not privately provided. If I was a litigant, I'd want a process or an option for a process that wasn't divisive. I would want a process that recognized the importance of ongoing relationships, future relationships. I'd want it to be timely. I'd want it to be proportional. I don't want to fight for 3 days over who controls a passport for a child or youth. I don't want to fight for 3 days over how Christmas is split up. I don't want to fight for 3 days over things like that. It needs to be accessible and affordable. Okay, I think there's 2 ways that judges can come to this. The first is judges need to become the manager of family law cases, especially in situations where people are self-represented. The adversarial system model, where the litigants are responsible to bring the evidence, decide the issues, et cetera, doesn't work. Our court is in the process of passing rules that will allow us to say to litigants, these are the issues, this is the order we're going to deal with them in. We want you to file affidavits. These are the issues we want in the affidavits. The affidavit cannot be more than X pages long. This is how much time you'll have in the courtroom. This is how much time you'll have to cross-examine. Basically, to manage the proportionality issue that the Supreme Court of Canada has signaled is a major issue. The literature calls that case management, issue management. We need to recognize that that's a pretty significant departure from the traditional adversarial model. It doesn't mean that if the parties have 2 lawyers that they can't, revert to something that approaches the traditional model, but it also means that judges have authority to rein in the lawyer who's out of control. I think you're going to see rules of court across the country adapt to change this. These rules are based on what's happened in the UK, and in the UK the rules evolved because of one thing. In 2010, in the United Kingdom, they got rid of all legal aid for family matters except child protection. Just like that. So in the UK, the courts were hit with this overnight it changed to a significant number of self-represented litigants. And this is the response to them. I think, too, apart from managing and developing, or assuming responsibility for managing cases and the proportionality of them, judges also have to create some new processes. So a settlement conference is one kind of process. That's where you and your partner would meet with a judge, with or without your lawyers, and the judge would be responsible for helping you to negotiate your way to a resolution. In that role, in that position, my role is quite different. I can be creative. I can suggest things. I can't do that in a traditional trial process. So somebody, if you have the benefit of appearing before a judge who's got some experience, and learn from that experience, then you're going to have access to that in that process. Binding settlement conferences are now starting to be done in our jurisdiction and a number of other ones, and that's basically where the people say, we want to try to negotiate this, but if at the end of it, if we haven't resolved all or some of this, we want you to decide the case. Now, a Court of Appeal case by the name of Abernathy in Alberta, which was a civil case and is a few years old, basically said that the parties can agree to whatever process they want. And as long as they agree and the judge agrees, that process is on its face fair in terms of process. A binding settlement conference occurred. One party said, oh no, we didn't really want that. It was, as I say, it was an insurance case. And the Alberta Court of Appeal said, no, if you agree to a process, you're locked into that. And that's a signal to judges in this area, I think, that we should be more creative with process. In Newfoundland, Oregon, Alaska, and a number of other U.S. states, what's called an informal trial is developed and rules around that. And again, it's something that our jurisdiction, I anticipate, will adopt within the next 6 months. And it involves a situation where the parties agree that there'll be a half-day set before a judge. The parties agree that they will submit X number of pages of material to the judge. The judge is the only person who can ask questions, but the parties or lawyers can ask a time-limited amount of follow-up questions, and there's a decision made. So the process is managed. It doesn't get all crazy. Focused hearings are occurring, and I know that in Saskatchewan's QB does some of these. And what that is if you've got an issue that is what I would call a fulcrum issue, it's going to decide what happens with the case. Instead of doing a big trial with 7 or 8 issues, do the fulcrum issue one, and the rest is going to fall from it, instead of this big long trial over something else. I've done a number of issue-by-issue hearings, and what that means is instead of doing a traditional model where the parties come in and mom testifies, and she testifies about parenting, and she testifies about what she thinks her time with the children should be if the father's the primary parent, and what his time should be. And she talks about the property, and she talks about what was inherited, and she talks about what spousal support should be or not be, and all of that. And it's all one big clump. That's hard for the person on the witness stand to work their way through. It means they're on the witness stand without interruption for a long time. And as a judge, it's hard to absorb all of that. You're kind of picking threads and people are jumping around. So what we've started doing is doing issue by issue. So one of the issues is the value of the house. We swear mom and dad, and we've done this with and without lawyers. They each give their evidence on the value of the house. Judge makes a decision. Next issue, who will the house be listed with? Okay, deal with that. And it's piecemeal. And it's just a lot easier for everybody to absorb, including, I might say, me as a judge. We're exploring, the last thing I'll mention is we're exploring, and we hope to go with this in September, what we're calling online dispute resolution. And one of the things with access to justice is sometimes we forget about the lawyers. And what we're going to try to do, and we actually have the money lined up, and we're inching closer, and I'm learning a lot about how governments work. But what it will be is basically we want there to be hearings that are online. In other words, think of it as just a split screen, three screens, judges in the middle, parties on each side in their lawyer's office, and we're going to start it just with where there's lawyers. And what we want to do is we want to catch what we're calling the low-hanging fruit. So if rather than have the lawyer and the parties come to court and wait in line to determine what Christmas parenting is going to be, we can do that at a set time online. We've got a record immediately because it's all printable and that. And the feedback we're getting from lawyers is they absolutely love the idea of not having to getting a set time. Very specific issues, like for instance, whether a youth or a young person is still a child of the marriage and entitled to child support, whether there should be disclosure on a certain file of a new spouse's or a new partner's income, things like that, things that are very discrete. And we're hoping to essentially take those things out of our chamber's docket and provide some service to lawyers that and make us more accessible and less expensive to them. We don't want the lawyers to have to charge for the drive to the court, waiting in our waiting room while the case before them is delayed, and so on. So, in terms of what I see my role as a judge in the family law area, it's that I think that we've shifted and are shifting a judge's role from being an adjudicator, decider, to a manager, to a facilitator, to an innovator, and always to someone who's prepared to learn. Thanks for the opportunity to speak to you this afternoon.
Thank you for that very thought-provoking set of remarks. We have time for some questions. I'm sure you have some observations or questions you might want to throw out. Take advantage of this great opportunity to mine 30 years worth of experience in this area. Tanner.
Thank you for your remarks. Do you see any specific access to justice issues that affect solely rural Saskatchewanians?
Well, the last one I just mentioned, where we want to do the online thing, hugely. I mean, the feedback we're getting from our lawyers is that that an online service would be tremendous in terms of rural lawyers' access to courts on discrete issues. I grew up in Alberta, but live in Nova Scotia, and one of the remarkable things about my move to Nova Scotia was that people regard driving 30 miles a long distance in Nova Scotia, and I always kind of laugh to myself about, well, if you're in Saskatchewan, Alberta, that's kind of next door. So, but I think in terms of, back to your question, sort of access to counsel, access to legal aid, access to these things. But I think one of the real important things is to pay attention to process and be prepared to innovate with process. I remember I had a settlement conference one time that involved, two people who, in my mind, were nice people, smart people, capable people, both with family in the area, both with aging grandparents, everything, and absolutely committed. And the big fight was over who had Christmas Eve. And it wasn't even one of those ones where you could say, well, you take this one and then the next one. Like, they both wanted this Christmas Eve coming. And I finally said, this got nothing to do with law. Let's end this. Let's toss a coin. And we did, and it resolved it. So I think, and it, you know, at first I thought, well, am I doing something wrong here? And then I thought, no, like they didn't need to litigate this and have somebody else. Like, there was no law, there was no, I mean, it was somebody needed to throw a dart, and it may as well be a coin. And that's clearly not always, but I think that my point with that is just that the process need not be the complicated process that we're sort of traditionally wed to, and that we have to find some connection between what the dispute is and what the cost of the adversarialism is, and whether there's another way to do it that's creative. And I've mentioned 2 or 3, and I think one of the things I really feel strongly about is that there's probably people in this room that would have all kinds of ideas about how any given situation could be resolved that I would never think of. And so I think just creating an atmosphere where there's an expectation of innovation would be a really big thing in terms of courts, because let's face it, we don't think of courts as, you know, centers of innovation. And I think we really, at least in the family justice area, need to do that. And I think too, and that, you know, we're seeing that the adversarial system is an old system, and it's a valuable system, and it's served us all very well. And maybe the family justice system is the canary in the coal mine a little bit on that, and the need to change goes beyond that. And certainly the need to pay attention to process and maybe change processes is seen in the Me Too movement, in the events following the trial last week here. So process is really, really important. And, you know, I guess one of the things I'd say in terms of rural settings is, you know, help your judge. Tell him or her what you think would work. And one of the messages from that Alberta Court of Appeal case is that if you come up with a process that the 2 parties are going to agree to, chances are a judge is going to agree to it.
Wanda.
You've got about 5 issues wrapped up in that. To go back to the interim one, so the issue with interim orders from access to justice point of view, I think, is twofold. One, can you get in and get that interim order in a timely way? And there are some provinces where that's a problem. And the second is, if there's a massive delay after the interim order becomes the order. And if a couple of years go by before you can get trial dates, that's a real problem, and it changes what it does is it means that people will fight over that interim order more. So it actually increases litigation, because if you're going to have to live with something for a couple of years, you're less likely to compromise and say, well, I can do this for 4 months or 6 months. So one of the things there is, in my practice in Halifax, and I do call judging practicing just the way lawyers call it, but when I was sitting full time, and I'm not now, I'm aging out, one of the things that I didn't appreciate that I had that was really valuable is control of my own docket. So one of the things I did with interim orders is if a matter came to me on a contested interim basis, I set the trial date before we had the interim matter. And so if I was setting a trial date, and like this is February, if I could give somebody a trial date in a parenting issue that was in June or even before September, then right away we know, okay, we know the kids are in school now and we know where they are. We're not likely to change that right now unless there's something imperative. But we also know that the trial isn't going to go into another school year. So that if one of the kids is about to go to high school or go to middle school or go to junior high school or like something that changes schools, that we're not going to create a crisis by not dealing with it. So that kind of like anticipating what the problem is going to be is important, but having a court system that is got the ability to do that is really important too. And not all, I think in like, you know, we don't even have unified family courts in all the provinces at this point. So, you know, that kind of ability varies. The domestic violence reference in your question is like, that's a whole other area, and I do come back on that one to, you know, there are problems of proof. And at the end of the day, the judge who's making that family decision on a domestic violence issue is only as good as the evidence before him or her. And we need to give more attention to that too.
In the interests of keeping within the time frame, we'll move towards wrapping this up. But I know that Justice Williams would welcome questions if you want to come up after. And the conversation will continue this afternoon with the students who are in the family and family negotiation courses. And Justice Williams is joining us then. So just going to pass it over to Bree to thank our guest.
So please join me in thanking the Honourable Justice Williams for his time today. That was terrific.
Thank you.